We still have 4 minutes before we start.
Okay. Otherwise, are you well?
I'm good, Chair. How are you?
I'm good. And how is Advocate Gwebu?
Morning, Chair. I'm sorry, I had a small challenge. I'm okay, Chair. And how are you, Chair?
No, you have a small child, not challenge. That is a child. It's not a challenge.
Oh, Chair, I didn't realize.
The handsome young boy, eh? Is that your son?
Or grandson?
Or grandson?
My
He can't have a grandson. He's a grandson himself. Not yet.
Yeah, what did you do? Refusing was so efficient. The chief asked if you want fruit.
No.
It's fine.
Advocate Ramano? Advocate Ramano?
Yes, 21.
Are we still not ready to start?
Some members are
Just indicate to me when you are ready.
okay.
You want to move it back? And you mustn't elevate this.
No, it's fine.
It's fine. Remember, you're going to be here until lunchtime, so you must make sure you're happy. You can't be moving. But this one you can move with if you want to move.
Okay.
Then you take that one and then you move somewhere.
Chair, I think we can start now.
Thank you. Honorable members and members of the media, staff, you are all welcome to this historic meeting. Allow me, before we engage, to make the following remarks. In 1990, political organizations were unbanned and allowed to come together to find a peaceful political settlement to the South African conflict. Leaders of South African people, both black and white, came from the apartheid regime, Bantustans, Robben Island, prisons, exile, the underground, and the Mass Democratic Movement, MDM. Many of these people did not know one another. Some were born in exile and were seeing their motherland, South Africa, for the first time after their unbanning. But all these people, who included racists, communists, conservative and progressive African nationalists, were united by a single purpose: to dismantle the apartheid state and its Bantustans and tricameral parliaments, and establish a united, non-racial, non-sexist, democratic and prosperous South Africa. South Africans from diverse backgrounds met and produced the 1993 interim constitution, which laid the foundation for the 1994 democratic breakthrough. Working together, regardless of their background, South African leaders produced the Constitution Act 108 of 1996, which contained an entrenched and judicially enforceable Bill of Rights, of which Section 25 is part. This constitution laid down rules and procedures for any changes to the constitution to ensure that whoever governs our republic does not do so arbitrarily. Unlike the mothers and fathers of our constitution, we have lived together for more than 25 years and have come to accept one another as South Africans, as it was envisaged in the 1996 Constitution. As South Africans, we have been given a big log of wood and instructed like sculptors to carve out a beautiful statue. This instruction compels us to work together to produce a beautiful statue for all the people of South Africa, both black and white. In carrying out this instruction, we have no choice but to work together, like the mothers and fathers of our 1996 Constitution. As the chairperson, I shall treat all members of this ad hoc committee equally and attach equal importance to all contributions, regardless of the size and history of the party a member comes from. Last but not least, in my determination of the merits or demerits of the contribution, I shall be guided by superior arguments advanced. It will therefore not advance anyone's cause to insult those that they disagree with. Our differences should not make us one another's enemies. Let's engage in a battle of ideas without insulting one another. I shall now call upon the Parliamentary Legal Services to present a draft constitutional amendment bill for our consideration of its merits and demerits without casting aspersions on the drafters. In our consideration of the draft, let's make inputs informed by our political party mandates and let us reserve our comments on new issues, if any, where we have no mandates, and reserve the right to go back to our principals for further mandates before the next sitting of the ad hoc committee. The people of South Africa will judge for themselves who are the builders and who are the spoilers of this South African statue that I referred to. Now, with your permission, honorable members, I would like to call on the Parliamentary Legal Services team to make their presentation. Advocate.
Good morning, Chair. Good morning, members. Chair, I must admit, we were not made aware that we have to present anything. I can take members through the bill as it was advertised. Is that what the Chair has in mind?
No.
Chair,
Yes, Honorable.
point of order, Chair.
Yes.
We did not receive an agenda for this meeting. Can you share with us the agenda, please?
The agenda, as we said before, today is a historic day on which we begin to deliberate on the draft bill. That's the agenda. And we are saying, because after all the discussions, it is incumbent on the Parliamentary Legal Services to reconsider the draft in the light of the inputs by the members. Now, that's why I'm affording them that opportunity. But if they have nothing new to add, it means that I will open the floor to the members now to begin deliberations on the bill. You will recall that we gave all members a period until the 3rd to go to their political parties to seek mandates. So we now depart on the premise that you are all ready to engage. Honorable members, the floor is yours on this historic day. I see Honorable Dr. Njosi.
Thank you very much, Comrade Chairperson, and indeed, welcome your opening remarks. I think as a matter of principle and as a point of departure, we must refresh our memory of the mandate that was initially bestowed upon us by Parliament, which established the Ad Hoc Committee, or which established this committee. It was specific that we must put special consideration to amend Section 25 of the Constitution to make the matter of expropriation of land without compensation explicit. So there has to be a consideration of the entire section to make this coherent within the section itself. So it would seem to me that by implication does not limit us to some of the subsections only. I say this because we Comrade Chairperson, have to agree about the coordinates of our conversation. And I would argue that we say Section 25 and then say subsection 1, subsection 2, subsection 3, up to subsection 9. Agree about what must happen in each and every subsection. The bill obviously has only one line that it is proposing, if I'm recalling very well. And I would have thought that the platform you were giving was going to read out the proposed bill, so that it is the second coordinate that guides our conversation. So accordingly, 1, we are discussing the whole section. 2, we must hear the proposal. And then 3, the chairperson must then take us section by section, and then we agree what the each and every subsection, as it were, must read like. If we are leaving it, we are leaving it like that, like that. I say this because, Comrade Chairperson, we have 2 interests as a matter of principle. The first interest relates to subsection that should explicitly say property may be expropriated without constitution only under the general ambit that and the redraft geographic lines and borders that had happened in 1913. So we think that there must not be a limitation in this regard. Accordingly, we believe that it must be replaced to say no provision of this section may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the result of past racial discrimination, provided that any departure from the provision of this section is in accordance with the provision of Section 36, subsection 1. Parliament must enact the legislation referred to in subsection 6. That is what we believe. Honorable Chairperson, I just want to finally read out the section as we think it should be. Subsection 1, the state, including Parliament, executive and judiciary, carry an obligation to redress imbalances of the past through enactment of laws that will achieve redress and equitable redistribution of land of all resources. Subsection 2, property may be expropriated without compensation, only in terms of the law of general application for a public purpose or in public interest. We believe that there must be a removal of Section 3, and that it must be replaced with the state should be custodian of all South Africa's natural resources, inclusive of land, mineral resources, and water, and relevant legislation should be passed to clearly define and contextualize state custodianship of land, of natural resources. For the purpose of this section, subsection 4 should thus read: Subsection 1A, the public interest includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources, and B, property is not limited to land. 5, subsection 5, the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on equitable basis. 6, a person or community whose tenure of land is legally insecure as a result of past racially discriminatory laws or practices is entitled, to the extent provided by an act of parliament, either to tenure which is legally secure or to comparable redress. And then removal of subsection 7, which I have read already. It's a replacement. We are open to persuasion of the terminology in relation to the question of dispossession. And then we are also cautioning that the stage at which we are, we must not debate as if this amendment will not be followed by an act, which will then deliberate in detail the details thereof. We are not persuaded at all that the responsibility of land redistribution, the tools thereof should be put in the hands of the courts. That will result in judicial overreach on one hand, but also it is a statement of no confidence in the executive that is democratically elected and empowered by our people. The role of courts in a democracy is not to govern. The role of courts is to resolve whatever disputes in relation to the land, in relation rather to the law, which would have otherwise been agreed to by Parliament, and within obviously a broader constitutional prerogative that must always be agreed upon a priori. And that includes, human rights, separation of powers, and so on and so forth. So we can't give the courts this governance responsibility to be responsible for land redistribution. It must be seized with the executive. Thank you very much.
Thank you, Dr. Ngozi. I think you understood the purpose of this meeting very well, and also understood that today what we seek to do is to persuade one another. And therefore, we must listen to one another and be open to persuasion. And that's the only approach that can take us forward. I recognize Honorable Shibambo and Honorable Dr. Lotrich in that order. Honorable Shibambo.
No, thank you very much, Chair. Just quickly note my apology that I think between 10 and 10:30, I will not be able to participate, but I'll come to join back again. I just wanted to fully endorse what Komisambu is saying, Dr. Ndlozi has said, in terms of the amendment, but also to give context that as part of our mandate as the ad hoc committee, we're given a clear instruction that we should have regard of the work done and recommendations as contained in the reports of the Constitutional Review Committee and the previous ad hoc committee in terms of Section 25 of the Constitution. That is what the mandate is. But also it will be foolhardy and actually be a travesty of justice for us to only discuss the draft bill as is proposed without taking into consideration the so many submissions that were made in relation to the entire Section 25 of the Constitution. And to go back to the people to say, we're now consulting you again, but subsection, it will be problematic because the people on the ground, the submitters, already gave an opinion in terms of what we should do to all those subsections that are under Section 25. So a notion, I saw it's contained in the submission that was made by the Department of Justice now, that we must not speak to these other aspects except the draft bill. That is entirely problematic, and it's not consistent with how Parliament functions. It will basically be rendering the public consultations to be futile because our people have already given a perspective in terms of how we must proceed. So that is the context, Chair, that we must never even doubt ourselves that we have an obligation to look into the entire Section 25 and then we propose to Parliament for adoption how each and every section should be rephrased or retained or deleted in a manner that has been proposed by Honorable Dr. Ndlozi. So that is how we must proceed, Chair, in terms of what happens. And I think that the spirit of engagement and persuasion should guide all of us in terms of how we finalize on this. And just quickly note my apology for the next 20 minutes because I'll be in a space where it's not possible to gain access to this meeting.
No, thank you very much, Honorable Shibambo. I think you have made your position loud and clear, and that will also empower other members to engage with what you are saying to persuade others. So I will allow Dr. Lotrick and then Dr. Melder.
Thank you very much, Chair. First of all, I want to refer to the comment you made in terms of this being a very historic day. It is historic in the sense also that we are celebrating 25 years of our very progressive constitution, but today we want to start a process where we actually want to put people's property rights in jeopardy. So I think it is historic also in a different sense. But Chairperson, what is important is that following the previous inputs, we cannot proceed without having absolute clarity about our mandate, because any discussion hereafter will have to refer back to what, as a committee, we view to be our mandate. And I again refer to what we have in writing. We cannot now add things as we feel as a committee. There is a very clear process in Parliament, and you know about it, that should we go beyond the mandate, if we want to go beyond the mandate, we have to go back to the National Assembly for approval. And I want to read our mandate again. Amends Section 25 of the Constitution to make explicit that which is implicit in the Constitution with regards, very specifically, with regards to expropriation of land without compensation as a legitimate option for land reform. Nothing more, nothing less, and that is the mandate. So it would be a futile exercise for us to go into long deliberations on different sections of or clauses of Section 25 if we are not at idem in terms of our mandate.
Dr. Melder.
Thank you, Chairperson. Good morning, colleagues. Thank you for the opportunity. The Honourable Chairperson, you started off by saying that today is a historic day. That is indeed so. It is the first time in 25 years since the adoption of the current Constitution that any committee of Parliament is going to attempt to amend the Bill of Rights. So that is historic, and it's got huge implications, obviously, and that's why the Constitution has specific provisions in terms of how one should or could amend the Constitution, as well as specifically the Bill of Rights. And obviously, we will have to operate within those provisions of the Constitution. Now, it is my view that we are not only dealing with Section 74(2) of the Constitution, which specifically deals with the Bill of Rights when we try to amend Chapter 2, We also have to take cognizance of Section 74(1) that deals with the founding provisions of the South African Democratic State, the one that the Honourable Chairperson referred to in the beginning. And that specific Chapter 1 deals with the founding provisions of our constitutional state, specifically Chapter 1, Section 1, which deals with the founding values, the basic values on which the constitutional dispensation is based. And then Section 1C clearly refers to supremacy of the Constitution and the rule of law. Now, to some, the rule of law may mean that you have to act and do whatever you need to do, even if it's amending the Constitution or whatever you try to achieve, by doing it in a legal manner and following the law. But I'm afraid to say that the rule of law means much, much more than just procedurally being correct. The rule of law has an application of what the rule of law means. And if you look internationally in terms of what the rule of law means, you'll find that it has also specific interpretation in terms when it comes to the law to own property. Now, what we are trying to achieve here in terms of this process is to take away the right to own property by certain citizens of the state. That can never be in terms of the rule of law. There's a huge distinction between expropriation as provided for in the current constitution or in any other constitution in terms of a law of general application in the interest of the state. Everybody understands that. But that's not the intention here. The intention here is to deprive certain people of property in total, and to do that at a compensation where the value will be nil. And I'm very sorry, but we shouldn't mistake expropriation without compensation with confiscation. If you take away people's property arbitrarily, I'm of the view that we're talking about confiscation, and we'll get back to that. The Honourable Dr. Lottridge is absolutely correct that we are bound by the mandate. She read the mandate. We don't have any other mandate. And I understand that some of us now try to interpret the mandate in a different way because we have different views. That may be your view, but that is not necessarily the mandate, or not even necessarily. It's definitely not the mandate of this committee. It's not the mandate we were given by Parliament. And if we now try to change the mandate in the process of what we are busy with, it also has huge implications. Because if you try to amend a provision of the Constitution, and I'm referring you once again to Section 1C, which is the founding provisions and the implications of what the rule of law really means, there you obviously you will take note that Section 741 expects of Parliament to amend that provision with a 75% majority, and that's where this will end. If you don't think that we are breaching the principle of the rule of law, you will think that you can get away with the Section 74(2) with a 2/3 majority, and certain parties may think that they can play an important role in providing that 2/3 majority, but you'll need 75%. Be that as it may, if you look at the mandate, when you do this whole exercise, you may find yourself foul of two things. The first one may be procedurally that you've got a problem. And if you make any mistake in terms of the procedure in this whole process, the exercise may fail purely on procedure, never mind the contents of what you're trying to change. Now, if you want to go outside the mandate, and the mandate is clear, Dr. Lottridge just read that mandate, then you must understand that you will be foul of the process, because the whole public participation process in terms of what is expected of us and in terms of provisions and findings and judgments of the Constitutional Court was in terms of our mandate. The public was not asked to comment on the things that is now being proposed and in terms of rewriting the whole Section 25 and the state should take control of all natural resources. The one natural resource that was not mentioned, I was wondering about that, is the question of fresh air and the wind. It was not mentioned. The wind can be used to harness and to create for electricity purposes, other purposes. That was not meant. Again, I guess that would be included. But if we go down that route, it's clearly not part of the mandate. The public was not asked to participate. They were not asked to express themselves. And I just want to warn, if we go outside the mandate, we will fall foul of the whole procedural process with all the implications. The second one would be in terms of the contents and the application of that as well, in terms of the rule of law, in terms of the interpretation of what the rule of law really means, in terms of the right to own property. So, Chairperson, I would ask us to stick to the mandate. If we don't do that, we will have a problem. And once we get to the arguments, I really appreciate that the chairpersons say that we are open to be convinced each other. Let's try and do that. And I will put the necessary arguments on the table once we get to that point. Thank you very much.
Thank you, Honorable Dr. Melder. I have no intention of channeling anybody, but I just want to appeal to those that come in now to address, among other things that they want to address, the status of the public participation. To what extent, if any, should we take into account what the public has said? Because as it was suggested, if we don't take that into account, it means that it was not necessary to even have public opinions. But I have no opinion on that. I'm just sharing. I'm saying let's address that matter, because it also affects the issue of the mandate. But also when we deal with the rule of law, because the rule of law in Africa and the third world has a history dating back to the report of the International Commission of Jurists of 1951 and of the 60s, where the rule of law was defined in the African context, because you had to take into account the historical context in which the rule of law had to be applied. So, honorable members, I recognize Honorable Kawa, but I must say that I'm really very impressed with the contributions of Dr. Ngozi, Honorable Shibambo, Dr. Melda, Dr. Lotrich. I think they all understand why we are here, and I hope that those who come after them will take their example, and go to the issues straight away. Dr. Honorable Kawa.
Thank you very much, Chair, and good morning, colleagues. I disagree with Dr. Mulder that the process of amending Section 25 implicates Section 1C of the Constitution, and thus the majority required to pass the bill will be 75% of the members of the National Assembly. When he started, he cautioned us against imposing our own individual views on the process. This is his interpretation of what the rule of law means in this regard. I would suggest that we don't get bogged down on what the majorities will be required, whether it is 75% or a 2/3 majority. Parliament will make that call at the right time. For us is to produce a bill that will serve before Parliament. We don't have much time. We're given until the 31st of May to conclude our process and submit our report with the proposed bill to Parliament. So I'm therefore advising against debating the matter of the majority is required at this stage, because we're not called upon to do that. Parliament will make a call when it has to deal with the bill, or the bill is formally before it. However, I agree with Honorable Rotrich that we must, have the mandate of this committee at the back of our mind each time when we engage with the different sections or provisions, of Section 25. In the last meeting, we had agreed that, Chair, your team will retrieve the mandate so that we don't give different interpretations to the mandate. The mandate is very clear, is written in plain language. Therefore, we must use it as the point of departure. So the team has done that. The administration has done that. I've seen the first resolution. I've also seen the resolutions of the CRC, the Constitutional Review Committee, whose report gave rise to the ad hoc committee that we are all members of. So I don't think we are far away from what we have been mandated to do as an ad hoc committee on Section 25. And again, we must not take a view, it's still too early to take a view that the views of the public don't matter. We went out to the public, facilitated the public participation. It was not out of choice. The Constitution mandated us to do exactly that. What's the purpose of public participation if we will not listen? We will only hear, but not listen to the views of the public. We will be accused of, ticking the box, and it's the money the Parliament paid for us to undergo the process. It's so much that we can't risk being accused that we did not do justice to the process. So mine, Chair, is to say, let's go back, let's deliberate, and we are guided by the legal team of Parliament. Go right from the beginning. What did the public participation, what does the bill say? What does the public say? What do we say? Right from the first clause, right up to the last clause. And then the legal section will advise us as to, in the event, I think they did it previously, that we touch on the clause that was not in the published bill. What then is the process that must be followed so that we remain within the framework of the law? But coming back to what Honorable Dr. Ndlonzi said, with respect, I disagree. And we're dealing with the property clause here. We're not just dealing with Section 225. It's not about land. It's about property in general. Therefore, you can't overnight say people have lost their right their right to property of whatever nature, of whatever nature. I mean, that will be a broad day robbery. Let's confine ourselves to the issue of in hand. That issue on hand is land. And so we separate, in other words, property, land is property, but property is not just land. Property is more than land. So as we discuss it, we need to have that in our mind that in the sections, section 25, there's land that we have been talking about, and then be clear as we make our proposals that we don't go beyond that. Thank you very much, Chair.
Honorable members, I think Dr. Lodrich and all of you are right in saying we must proceed on the basis of a clear understanding of our mandate. And our mandate says, make explicit what is implicit in the Constitution. And that raises the further question, whether or not we should read section 25 as a whole or focus on particular sections. So I'm just saying that let's bear this in mind, engage on this thing until we agree or disagree. But whether or not we are exceeding our mandate, I think we cannot be judges in our own in our own case. Let's focus on the text. And in case we exceed our mandate, we cannot judge ourselves. The Parliament will call us to order and redirect us. But let's proceed on the basis that we have the right to do what we are busy now, focusing on the text. Honorable Kawa, thank you very much for your contribution. And I think all of you are really doing what is expected of us, and you are all seeking to persuade one another, and that's how democracy functions or should function. I see Honorable Mahlatsi. Proceed, Honorable Member.
Thank you very much, Chair, and good morning to colleagues. Chair, let me join in the debate or the discussion of this morning regarding this particular process that we're embarking on. But firstly, I must ascertain myself as we deal with the actual mandate of the committee. Prior to the release of the bill, Chair, the African National Congress made specific inputs into the bill. However, in that meeting, because the bill had to come out the week after we had made those inputs, Parliamentary Services itself did indicate there was a general compromise in terms of how the bill must go out, and we all agreed in the committee that the bill can go out in its form, but it will take cognizance of the inputs that were made by all political parties in that particular meeting. Now, I'm a bit surprised today when the same legal services comes here and says we need to confine ourselves along the lines of what has been taken out in the bill, over and above the fact that we will not be doing justice not to listen to the public participation processes and the people who are speaking in the public participation processes. Now, maybe they must clarify us, because we, as the ANC, we made inputs in terms of what we wanted to see in the draft bill. But however, because of the circumstances that we were facing in that particular meeting, and it is on record, Chair, those inputs of the African National Congress, they are on record. Now, I don't understand the view that now if we had to reverse the process and so on, maybe legal services must clarify us on that part first before we even move forward. Thanks, Chair.
Honorable members, I think Honorable Mathatsi has repeatedly said something that has been the position, that we published a compromise bill to be able to kickstart the process. And at that point, not the views of all political parties were taken into account. And what she's saying now, whether or not we should be confined to the bill, is absolutely correct. But I'm not sure that we should even ask legal services to tell us. It is for us as the political parties, because it is us who made the compromise, whether we should allow the compromise to exclude the views of the public, which would make nonsensical the principle of public participation. So with your permission, Honorable Mathatsi, let's hear what other political parties are saying. This is our time now. But we have raised the issues quite clearly. I think everybody has understood. Let's engage. I see Galaxy S20. Is that Honorable Gumede?
No, Prof. and Chairperson, it's Muratev.
Oh, this is the principal.
Yes,
Oh.
my Prof.
Yeah,
Good morning.
Yeah, good morning to you. Don't announce results before the exams.
Good morning, Chairperson and other members on the platform for this ad hoc committee. Chairperson, I think your introduction and what you have just said now, of course, coupled with what majority of members have contributed, is taking us where we are expected to go. Chairperson, in the first place, the mandate from Parliament was never given to any other person except this committee, which you are chairing. Any other person who comes with an advice, it's a view. And such a view we can only note, but we stick to the mandate as per the Parliament. I'm saying so, of course, based on the view which is brought now by the parliamentary legal team. And I want to support Honorable Mathatsi that let us not be swayed by their view. It's their view, but let us stick to the mandate, which mandate we got from Parliament. And I also want to support what Honorable Ndlozi and Shivambu indicated as they started it. And to indicate that ours is to go to the clause of the Constitution, to the section of the Constitution, and go subsection by subsection, and at the end of the day, arrive at the desired mandate where we shall have made explicit what is implicit. You see, some people, when they were speaking, we have listened to the public participations, the public hearings, and we have listened to and read also the oral inputs of other people. But what remains is, at the end of the day, when we go back to Parliament, the inputs in the bill should be making explicit what is implicit. That is the bottom line. And hence, any other inroad which will sway us from that mandate will be irrelevant, and we are not going to accept it. And I agree with you when you say we may not even ask the parliamentary legal team to come here and explain what you got. No, they have given their view, and ours is to stick to the mandate of Parliament. Thank you very much.
Honorable members, we are interpreting the Constitution. The law of interpretation says that when you read a document, you read it as a whole. Now, our mandate is to make explicit what is implicit in Section 25. Now, that means that the subsections of the Section 25 must be read together because they are intertwined, they are mutually reinforcing. So I want to agree with the Honorable Ndozi Shibambo and Honorable Mrasela that let's read the Section 25 as a whole. But if at the end we find that it is wrong to read it as a whole, it will be our decision. But let's not compartmentalize the sections at the beginning of this discussion. So can I open for Dr. Ndozi and Dr. Melda? Honorable Ndozi?
Thank you, Honorable. Yes, Honorable Chair, am I audible?
Very well.
Thanks indeed. I want to do a reread of, we must not be selective when we read what the mandate is. It seems our honorable members, they always stop at, the resolution has about, let's call it 1, 2, 3, and then sections. And then the second point, which establishes the ad hoc committee. I just want to read it so that we move from the same. We don't. There are things we can no longer debate, I think, and I will point them out in a moment. So it says, establish ad hoc committee in terms of Rule 253. The committee to initiate and introduce legislation amending Section 25 of the Constitution. Have regard to the recommendations as contained in the Constitutional Review Committee report. Consists of 11 members, consists of 14 non-voting members, exercise those powers as set out in Rule 167. And then that is the sort of entire resolution which establishes us, how many we must be, what we must discuss, and so on and so forth. So if you have regard to those recommendations of the Constitutional Review Committee report, you will know that it's a very thick report which was written after public consultations. So here is the point. We've already agreed. We can't go back. We've already agreed. The Constitution is being amended to make explicit expropriation of land without compensation. We used to debate whether we should or not, but we are no longer debating that because the horses have bolted. Now, there are submissions which want us to review that decision. Unfortunately, we don't have that mandate. There was a committee which had that mandate. That committee wrote a report. That committee submitted the report to Parliament. Parliament then adopted the idea that the Constitution must be amended and set up a committee to amend the Constitution for expropriation of land without compensation. It is in this regard that we must answer the views that say such an amendment, is going to be a violation of human rights. Why I'm saying that, Chairperson, is because we've had this debate. What we then are seized with now is in what words must this amendment take place in which part of this section, and so on and so on. Now that's where we are. So we can't keep repeating, then we don't take the very processes we keep referring to, we don't take them serious. So if we're going again to say, you know, are we supposed to expropriate land without compensation or not? That the horses have bolted on. And to remind all of us, we do this because when we talk about land reform, we're saying that there was a time where a crime against humanity occurred. And this time lasted for a couple of centuries, in which there was a racial or a racist dispossession of land by the apartheid and colonial regime in favor of white people. That's what we're trying to correct. We're not trying to make people property less. We're trying to correct a crime in a way that makes the future from here on not exclusionary to Black people in relation to the ownership of the land. So we're going to amend the Constitution. It is no longer, it's not happening, that debate anymore. So the attempt to keep taking us back is inconsistent. The second thing, Honorable Chairperson, that we must clarify is this idea of when we expropriate land without compensation to correct a crime against humanity, it's inconsistent with the rule of law. That argument, unfortunately, it must be dismissed as dishonest. Because the rule of law is a principle that all of us must be subjected equally to the laws, and that either the government or individuals or groups cannot arbitrarily conduct themselves with disregard to the general laws of the country. So no matter how angry I am, I cannot kill, I cannot murder, even if you know, I'm convinced that whatever the person or the other group has done to me, I'm restricted, I'm restrained. I can murder, I can kill a person, but I'm going to subject myself to the law that it is wrong to murder. And then take whatever the person has done to me to a court or to relevant structure so that they can resolve the disputes through the law. So what are we doing now? We are setting up a law to which we will all be subjected to. How are we setting it up? We did public consultations. We are doing it democratically by a democratically elected parliament. That law will be subjected even to a constitutional review. I mean, to the court of the law. It can be taken even to a court to check if it is consistent with the Constitution or not. The final point is this idea that we cannot amend the Bill of Rights. It's also not true, like it's just not true. We can and we should, because we are demonstrating that in this case, this is an impediment to the achievement of human dignity, to the achievement of equality on the basis of race. We must expropriate land without compensation for the correction of a crime against humanity, which is the colonial dispossession of land in favor of white people from Black people. If we're still debating these things from a different perspective, then we're not in one spirit, Chairperson. So that it's inconsistent with the rule of law. It's unfortunately just a wrong interpretation. You are actually referring to if you want regard to the protection of that principle. It cannot protect you, because what we are going through now is precisely in keeping with how in a society guided by the rule of law, the rules themselves or the law themselves should be amended. We must be able as a democratic society to adopt laws. How do we do it? We do it exactly like this. This is the rule of law. This is the rule of law in function. We are not finally making an arbitrary law. We are actually, in relation to property, saying we are going to expropriate property because, by the way, there are a lot of even white people who don't have land in this country. A lot. There are few families who own the land. Few white families. They're a tip of the iceberg, at the top of white society. When we redistribute the land here and 80% of it belongs to Africans and so on and so forth, there are a lot of white people in the 9% of the population of white people in this country who are going to benefit, who at the moment don't have land. So if we are accused that it's going to be a racist discrimination, that too is a desperate attempt at stopping a process that in any way is going to correct a far much bigger problem. So we must be unapologetic. And those who don't share in this spirit must not keep taking us back, with the greatest respect. Where are we? We are amending the Constitution, because that it must be amended is already a decision. And then my final comments, Chairperson, I just want to say, we have put a proposal, and I recall that section by section was an agreed way forward. And we agreed, as well as the NC at the time, that, okay, release the bill as it is. But people have made submissions section by subsection by subsection. And I think that we must move in that regard, as I have indicated. But these arguments of the rule of law, these arguments of general application inconsistency, and I agree with the honorable member that majorities that are needed is not our mandate. We don't have that debate. When we table the final process, you will hear there whether we need 66% or 75%. Whatever percentage we need it's irrelevant at this stage. Let us stick to where are we now? Is what do we say on section 1, subsection 1, subsection 2, subsection 3, up to subsection 7? That's where we are. We're no longer debating whether we are amending or not. We're no longer debating whether we are expropriating the land without compensation or not. We are going to do that. Let us find a way to put it in the Constitution now. That is our mandate. Thank you.
Honorable members, with respect, let's not reinvent the wheel. The debates on human rights, on the rule of law, have already taken place. The debate about forceful disposition as a crime against humanity, as the original sin, all those things have been dealt with. Now, where we are is to deal with the text. So anybody who has notions about rule of law or human rights, let your notions influence your formulation of the text, because now what we are doing is to formulate the text. I did a master's degree at Harvard University in the United States on human rights. I did my doctorate in law on the concepts of law and justice in the African context. I know that there are different interpretations on these concepts, but for our purposes now, we are not in an academic exercise to define concepts. Our mandate is to formulate the amendment of Section 25 to make explicit that which is implicit. That's what we are busy dealing with now. And I see that Honorable Ngozi agrees with what Honorable Matlatsi is saying, that the bill published was a compromise. And I'm pleased to say that that compromise was actually produced by Honorable Dr. Melder. Dr. Melder is the one who ensured that we get a compromise so that we can kickstart the process. So let's not go back to that debate, but let's say now we are dealing with the text and confine ourselves to that issue. So I see the Dr. Melda, do you want to come back? And Dr. Ngozi, are these old hands?
Yes.
Honorable Matlazi, do you have another?
My chairperson.
Mine, Chairperson, is covered. You can proceed. I've lowered.
Thank you. Honorable Melda. Honorable
Thank you,
Dr.
Chairperson. Thank you for your input. I couldn't. Yes, thank you, Chairperson. I couldn't follow exactly what you were saying just now. The sound was not quite clear, but I'll try to react in the way that I think from my perspective. I've listened to what the Honourable Dr. Ndlozi has said, and my problem is this. Building arguments on myths does not necessarily make them true. It doesn't help. Now, Honourable Chairperson, you also mentioned that we've already discussed the whole issue of the rule of law and the Bill of Rights. I'm not sure where those things were discussed. I've attended, I think, most of these meetings. I can't remember that we've discussed those. But you make the point that they were discussed. You also make the point that you have studied at the University of Harvard and that your doctorate is in certain issues with regard to law. If it may assist, my doctorate is also in law. It's in constitutional law. So if I say some things about the rule of law, it's because I know certain things about the rule of law. And we can all have a different interpretation. In the end, I guess the Constitutional Court will interpret the rule of law in terms of this whole process. Now, Dr. Ndlozi referred to the whole issue with regard to the Constitutional Review Committee, the report, etc., that was drafted by that committee, and it was brought to the House with certain recommendations. We, however, should not forget that more than 500,000 written submissions were ignored by the Constitutional Review Committee, submissions against the whole process, and it's not going to go away. That will surface again when this case goes to the Constitutional Court. We all know that. So we can't just say this was the report. The question is if that report was flawed or not, or that process was flawed or not, and the time will tell. So the current mandate says that we should have regard to the recommendations. Yes, we should have regard to that. But what I don't understand, Honourable Chairperson, is why do you read the mandate every time and then you stop? You just read the mandate to a certain point by saying that we should make explicit what is implicit, and then you stop. Why don't you read the qualification again and focus our minds, because Dr. Lottery correctly read the total mandate. We should make explicit what is implicit with regard to, and then it clearly states what we should do. You have just now, before this last round of discussions, made the point that we should make explicit what is implicit, and then you wanted to refer to the whole of Section 25. That is not our mandate. And you can now rule that that is our mandate. That would be your interpretation. That would be not in line with the decision taken by the Parliament. That would not be in line with the mandate that we have. That will not be in line with the mandate. So even the compromise bill that was published, did we inform the public when they participated that this is a compromise bill, that we will listen to them, but the committee will then all by itself go and amend Section 25, take it section by section and go right through it from the beginning to the end? Dr. Ndlozi refers to the whole question with regard to the disposition of land. Perhaps we should then also discuss who dispossessed the Khoi and the San of their land. And we should go way, way back perhaps and have a look into that as well, because it's not that simple. It's not that simple to just make this a white-black issue. It's not. It's definitely not. I would like to know from Dr. Ndlozi, what is the position with regard to the traditional land being occupied or being owned by the traditional leaders in South Africa? Is that also part of this process? Or are we excluding that? And then we are going to say, this is a law of general application. However, those lands are not to be touched. Is that the case? Or are we talking about all property? This is not only a white or black issue. This deals with the right to own property. And there are, unlike what Dr. Ndlozi thinks, the property and land in South Africa does not belong to a few individuals. There are a couple of million also black people who own property in South Africa. So it's not that simple. It may fit a certain narrative, but that's not the case. My concern, Chairperson, is this, and I'm going to be honest with you. It's quite obvious that a certain political party, the party that Dr. Ndlozi belongs to, has taken the initiative on this whole process since day one. They were the ones that brought the first motion in 2018. The ANC then followed. They were the ones that formulated the resolution in the Constitutional Review Committee. The ANC followed. And it's quite clear in this current process that the EFF is taking the lead and the ANC follows. Now, my concern is this. I understand that if you are working in terms of the 2/3 majority, in terms of Section 74(2), the ruling party needs a 2/3 majority. The only party, it seems, that can give the ruling party that 2/3 majority is the EFF. The ANC by itself is in need of 37 votes in Parliament, and the EFF has got 44 votes. So the question is, how far are we going to go through this process to try and accommodate the ideas of the EFF? And the EFF has made their ideas quite clear, very simply so, by saying that all property should belong to the state, that the state should be the custodian of everything. Is that the view of the ANC? If that's the view of the ANC, then we should go ahead with this whole process and implement that. If that's not the view of the ruling party, then I want the ruling party to clearly state that that is not their view, and we shouldn't waste time, and we should know that 2/3 majority is going to be a problem. I repeat once again that the rule of law is not going to be swept aside. It's not that simple. It's got certain implications, and that's why I referred ourselves to Section 74(1). Lastly, Chairperson, the bill that was circulated, that was published, and the public was asked to comment on that bill, that, as far as I'm concerned, is what we should discuss. We can't act now as if nothing was published, as if no inputs were asked or received in terms of that bill that was published. If we just want to throw that out the window and start de novo from Section 1, Subsection 1 of Section 25, we are starting a completely new process. Will have huge implications in terms of process, and I'm of the view that we will be outside our mandate. Thank you.
Chair, you are still muted.
I just want to put it out there that my hand is now raised, Chairperson.
Okay, comrades, honorable members, I'm saying that it is not the duty of the chairperson to repeat the mandate all the time. We have been working on the basis of our mandate, and Dr. Lodrich repeated it. I repeated it. Dr. Ndlozi repeated it. Everybody. Why should we plow the same field again and again? I agree with Dr. Honorable Melda that this is not a black and white issue. And I've said that before. This is a South African issue because all of us as South Africans, elected by all our people, both black and white, have been tasked to find solutions to the historical problems that we have. And indeed, we can think away the Khoisan, pretend they didn't exist. They did exist, they still exist, and they have even gone to the United Nations and they said quite correctly that they are the First Nations. And there is a resolution of the UN General Assembly which protects the rights of indigenous people, and the Khoisan people are indigenous people. So all these things we must take into account in our debates. So let's debate, but let's not talk about majorities that the ANC and the EFF need each other. This is not an EFF ANC matter. It is a South African matter. So let's deal with this matter as South Africans and forget our political labels, because the outcome must meet the aspirations of the people of South Africa as a whole, both black and white. So I open the floor again. I recognize Honorable Masipa, Honorable Ndlozi, Dr. Lodrich, and Honorable Shibambo in that order.
Chair, thank you very much. I just want to agree and concur with Dr. Mulder. The mandate of this committee is really clear to make explicit what is implied in the Constitution regarding expropriation of land without compensation as a legitimate option for land reform. So, Chair, you will see that with this argument that is put before us is that we need to just make explicit what is implicit. And it does not imply that we need to change the legal position. As such, it's not an amendment, but rather a clarification of how do we expropriate land without compensation. So as such, Chair, if the majority of the committee today feels that maybe we need to go beyond the mandate that we're given, we should be considering going back into the parliament and ask a permission whether we can go beyond our mandate. Otherwise, we will be in breach of what we were given as a committee, Chair. Because we went to the people with clear understanding when we were engaging with the public to ask them their input in making explicit what is implicit in this particular constitution. So, Chair, my input is that if we want to go beyond that, I think we should really consider going back to the parliament and obviously asking a fresh mandate in terms of this particular work that we are busy with. We are an ad hoc committee. We have been given this specific mandate to make explicit what is implicit in this particular constitution, which is section 25, amendment 18. So for us now to be debating, changing all other areas of the constitution, it will be really a breach of what we expected to do. So these are my inputs, Chair, and I think if we can just really focus on this making the what is explicit, what is implicit explicit, I think we will make progress, and the deadline we could be able to in the end meet. Thanks very much, Chair.
Honorable members, allow me to guide the proceedings. I said repeatedly that we have reached a stage when we must deal with the text of the 18th constitutional amendment. These other issues, debates are no longer relevant now. And if we formulate the amendment and in the process exceed our mandate, when we present our report to Parliament, Parliament will determine whether or not we have exceeded our mandate. But it's not for us now to stall the proceedings on the basis, on the suspicion that we may or may not be exceeding our mandate. That's not the issue now. If that issue arises, it will arise in Parliament. Parliament will deal with it. What we must deal with is the formulation of the text. Now, I am actually going to allow honorable members to deal with the text and not other side issues. I recognize Honorable Dr. Ndlozi, Honorable Dr. Lotrich, and Honorable Shibam. We deal with the text now, not with the side issues.
Okay, Chairperson, you are tying out my hands. There were direct provocations, which I think it is fair that we respond to them. And with the greatest respect to what you have just ruled, I started with the text and I stuck to the text. I made my proposal. And I want to repeat, if honorable members were to read the resolution, it asks us to follow or take consideration of the Constitutional Review Committee report. If you go to that report, Chairperson, if you go to that report, you will know that questions of Bill of Rights, rule of law were ventilated. Questions of history.
Honorable Ngozi.
I'm just saying, Chairperson, I'm merely...
Let me just guide the meeting. You opened the debate very well, and you dealt with the text. So don't allow people to take you out of the rail, because we will defeat the purpose of this meeting.
No, Chairperson, agreed. Let me accept your guidance. My proposal is on the table, and I think we're well within the mandate of Parliament to take Section 25 and make explicit in all of it expropriation of land without compensation to achieve land reform. I think that we must proceed in that regard. So I've put my proposal of each and every section. I don't want to repeat it, and I will desist from distractions. Thank you.
Thank you, Honorable Dr. Ngozi. Honorable Dr. Lotrich.
Thank you, Chairperson. I want to use this opportunity, and I know that you have now given some direction, but I want to concur with what the Honorable Mulder and Masipa have said. What I also want to state, Chairperson, is that I do not agree with your interpretation of our mandate in terms of that we can exceed it and then only we go to, or the National Assembly can then discuss whether we exceeded it or not. I want to refer you to an example of a committee where you were the chairperson, also an ad hoc committee where we had to amend the Powers of Privileges and Immunities Act after a constitutional court judgment. Now, in that process, when we were busy, we realized as an ad hoc committee that we were in fact going beyond the mandate of what the National Assembly gave us. We went back and we got the approval to proceed. And that is how we should be approaching this. So if we do discuss the bill as gazetted, because that is what the public had to comment on, we stick to the bill itself, then I would proceed with this discussion and partake in it. But Chairperson, if it is an open discussion where we include things not in the mandate, and the mandate is specific, a sub or ad hoc committee does not have unfettered rights to do anything they want to. We work on the mandate of the National Assembly. So if you could give clarity on that, and that we're not going to include all kinds of other sections, but that we include only that part of the mandate. Thank you.
Honorable Dr. Lotrich, you are correct in saying that when we dealt with powers and privileges, we were not sure whether or not we are exceeding the mandate. We went back to seek guidance, and that was a unanimous decision of that ad hoc committee that I chaired. But now in this meeting, we have differences of opinions, and we can't say if we are 10, 1 or 2 members have different opinions, and we say that is the opinion of the committee, and on the basis of those 2 opinions out of 10, we have to stop the proceedings and go back to the House. That would be very undemocratic. Let's continue with the text, because there's no disagreement that we should amend the text to make explicit what is implicit on the questions that you correctly raised. Let's confine ourselves to the text, and then we'll see as we move on whether we're exceeding the mandates or not. But at the moment, I am of the firm view that the question of the mandate, exceeding mandate, does not arise. What arises is the formulation of the text. So Honorable Shibambo, you are next.
No, thanks, Chair. I think the issue of the mandate has been clarified and everything else there, but I think it will be wrong if we do not sometimes refute some of the continued distortion of our history and the continued colonial stratification of indigenous Africans. We are indigenous people, all of us here. So that attempt, which is done mostly by Afrikaner racist historians, to try to say the coedicide and then black people and all of those things, there is a deliberate attempt to try to delegitimize a legitimate demand for the repossession of the land. That must be dismissed consistently, because that is what they wrote in the textbooks and everything else there, and then they continue to drive that narrative that we are separate human beings. We are all indigenous here. We didn't come from Europe. We're not settlers here. We're not descendants of settler colonialists in the manner that it is. So I thought I must deal with that so that we
Honorable Shibambo, you are right that that matter must be dealt with.
We are all indigenous.
No,
how do you accept Rowena? You are not African indigenous, Comrade Matol.
No, let me finish so that I can allow you to finish. Because if I have not finished, how do you finish? Yes, I'm saying in the amendment of Section 25, we have to deal with the question, the position of the Khoisan, the indigenous Africans, and so on. So we no longer need to debate that. We only need to formulate the section in a way that
that's fine. That's fine, Chair. Yeah, that's fine, Chair. Then I wanted to problematize this thing as well, which I understand is part of the compromised bill. And what do you think is the mandate? So if you go to Section 25 in the current formulation, in subsection 2, it says property may be expropriated only in terms of law of general application. And then it says in 2A, it says for a public purpose or in the public interest, and B, subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. Now, I don't know where is the implicit expropriation there, because there's nothing implicit about expropriation without compensation in the current framework. It says that if you are going to expropriate property, it must be subject to compensation in terms that are agreed by those who are they're exchanging the property ownership or approved by a court of law. So it's a problematic notion that seeks to suggest that the current constitution permits for expropriation without compensation. It doesn't. So that is one issue. That is why the formulation that was given by Honorable Dr. Ndozi earlier is the correct one, of altogether rephrasing subsection 2 of the Constitution in the manner that it is. The other issue which we must then locate within this historicization, which is being distorted deliberately here, is on subsection 3. So that the amount of compensation and the time and manner of payment must be just and equitable, reflecting an equitable balance between the public interest and in the interest of those affected, having regard to all the relevant circumstances, including one, the current use of property. Let's say that makes sense. The history of acquisition and the use of property. So that aspect that says the history of acquisition already supposes that those that occupy the land now have acquired it through legitimate means. It's not the case. They colonially stole our land. It's a fact. It was a colonial, barbaric, racist dispossession of the land. But here, you are going to be told, go and look into the history of acquisition. They have not bought this land. They don't even have a history of acquisition. Majority of them are just descendants of the original colonial settlers in the manner that it is. And we have to give this into clear context of what happens. That is why that subsection altogether as well must go, because there is no history of acquisition that defines settlers' relationship with our land currently. That is why we need to then rephrase it almost completely. I think that one of the issues that we have already said and are going to repeat several times is that if we do any amendment or effect any amendment and then leave subsection 7 as is, that will be the most foolish thing ever. It would have been a waste of time to then say we're only going to consider the land that was dispossessed post 1913. Post 1913, the indigenous Africans only had 7% of the land. That is a historical fact. So it means that we're only talking about 7% of the land. So that subsection 7 is altogether must be deleted. And if anyone ever suggests that we must retain that, that person is not committed to this process that we're engaged in here. So those are the textual, some motivations that we're giving, Chair, that let's deal with it in that particular format. The mandate issue, if the white political parties think they're contesting that, let them go and debate that in Parliament or adopt it. If they want to go to court, they can go to court, and then we'll go and justify that the mandate is within the context within which we're mandated by Parliament. I don't think that is a problem. Let us not be in a merry-go-round debating the same issue time and again. Let's effect changes to the text and then go to Parliament, give a report, and then if people have got concerns about that, they've got recourse, and then we'll take it from there. Thanks, Chair.
Chairperson, you are muted.
Yeah, I say with respect, I'm not aware of white or black political parties in this parliament. I think all parties have members who from all races, but that's not the issue now. I want to take us back to what Honorable Ngozi and Honorable Murasatha raised, that we must go section, subsection by subsection. Otherwise, unless we do that, we will be all over and nowhere. Now, is there anyone who disagrees with that proposal of Honorable Ngozi that was supported by Honorable Murasatha, that we go subsection by subsection? I see Honorable Kaba, Honorable Melda, Honorable Ngozi, are these all on your hands? But I first want us to settle the question of whether or not we should go section by section.
Chairperson, I agree with that approach. My hand was on the earlier discussion, but I think let's follow your guidance because it helps us to structure the discussion. Because yeah, let's follow that. Then as we deal with questions, we look at what each one is saying, and then we discuss it. If we agree, we put that behind us and then go to the next section. Thank you so much, Chair.
Thank you. Honorable Melda, Honorable Dr. Lotrich, what are you saying on that approach?
On that specific approach, Chairperson, I do not agree with that. I think it's wrong. I think it's outside our mandate. I think we should stick to the bill that was published for participation and for input from the public. And I think we should discuss that proposed bill and the implications of those amendments on the current Section 25. Secondly, I would just like to refer, I find it astonishing that the Honorable Shivambu can't think beyond race. Everything in his world is black and white. It's a tragedy, and I don't think it will take him anywhere.
Okay, Honorable Ngozi.
Chair, it was me first.
Oh,
Dr.
yeah,
Lotrich.
Dr. Lotrich, yes.
Thank you, Chair. No, I don't agree to go through it section by section. We go through clause by clause of the bill as we have it today. That is what was presented to the public, and that is the mandate of this committee.
Honorable members, let's agree that our mandate was to deal with Section 25. And Section 25 has 25, 1, 2, 3, 4, until 9. And the law of interpretation says, when you read a document, you must read it as a whole, because things are intertwined, interrelated. So we will not be doing justice to Section 25 unless we read it as a whole. So I want to rule that the most sensible thing in terms of the rules of interpretation are to deal with Section 25 clause by clause. And I open the discussion now on that basis. Honorable Kaba, do you want to start?
Yes,
Honorable-
Chair.
Yeah.
Oh,
Okay.
I thought
On clause 1, Chair.
Yes.
Let me read it first so that we all are on the same page. Section 1, 25.1 reads, no one may be deprived of property except in terms of law of general application, comma, and no law may permit arbitrary deprivation of property. And we propose that this clause remains as this clause remains as is, and that is our proposal. Chair, maybe we can then check what other parties are saying with relation to this before we move to the next text. Sorry, provisions.
Thank you, Honorable Kaba. Honorable Njosi.
Thanks, Chairperson. It's not going to help you, Dr. Honorable Mulder, to be a historic denialist as well.
Honorable Njosi.
Mark Chairperson, when you allow him to speak, you don't allow us to speak.
I've got a history handbook. You provide your handbook, we'll discuss it. Bring your handbook, we'll discuss it.
Honorable,
you allow Dr. Mulder to say things to us, but now when we react, you don't want.
Let me tell you why I allowed him.
Okay.
Honorable Njosi, you have provided leadership and said, let's deal with the text. Now we have begun to deal with the text. Now, if you follow what Honorable Melba is saying, you will derail yourself. Do you want to derail yourself or focus on the matters at hand? I suggest that you should not derail yourself. Proceed on section 25, subsection 25.1 and continue to provide guidance.
Thanks, Chairperson. No problem. It is here that we want to persuade honorable members on this question of the democratic state. And I think that from time to time we have used the example of the MPRDA, in which, minerals were put under the custodianship of the state. It didn't create any problems that you then get to the question of a lease. A lease is a form of a property and a form of a property right which is legitimate, and it can be protected. So that in the future, no race or no group which can define itself using whatever features in the future can repeat what happened before. Either it be ethnic groups, religious groups, or whatever the case might be, through the power either of their brutal strength or their financial strength, can ever take us back to the situation that we are in now, in which majority of the people don't have access even to something as simple as settlement land. So the democratic state from time to time will be able to make sure that there is this access to the dignity of settlement land, of agricultural land, and so on and so forth. This is extremely wise with the history of South Africa, and the actually correct history, not the wrong history, not the history apartheid wrote to legitimize itself. The correct history of dispossession If you are going to disallow that in the future, we must relate to the land with the correct way in which we were relating to it, which is, in the end, it always belongs to a future generation. And therefore, we are borrowing it as this generation. How do we make that to come out in a proper way? Is that it must always be under the custodianship of the democratic state, as well as, and by the democratic state, we include traditional leadership. They are part of the democratic state. They are part of the executive arms of a democratically arrived at state, who will administer on behalf of the people. So we argue that it must explicitly read to say that subsection, the state, including parliament, executive, judiciary, carry an obligation to redress imbalances of the past through enactment of laws that will achieve redress and equitable distribution and equitably distribute all resources. The state, including parliament and the executive and judiciary, carry an obligation to redress imbalances of the past through enactment of laws that will achieve redress and equitably redistribute all resources. Because we're going to propose, as I said, that principle later on of custodianship being in the hands of the democratic state. So the mandate of subsection 1 should read like that. The state, including parliament, executive, and judiciary, carry an obligation to redress imbalances of the past through enactment of laws that will achieve redress and equitably distribute all resources. Thank you, Chair.
Thank you, Honorable Ndosi. I can see now you are back to the ray, and that's what we expect in this meeting. Honorable Dr. Lothric.
Thank you, Chairperson. I just want to now use the opportunity to state categorically that the process we are following now, discussing the sections of Section 25 one by one and not confining ourselves to the bill as presented to the public and to this committee, is outside of our mandate and it is not procedural. And therefore, we will not be part of this discussion. We will be part of the discussion within the mandate of this committee, and that is to discuss the bill. Thank you. And could this also please be minuted?
Chairperson?
Who is that?
Chairperson? It's
Yes. Yes.
Can I just come in here? What we have before us at the moment is the bill as advertised. This one here. So I think what we should be doing, we should be looking at the text that we publish for comment and then give instructions to legal services. As we do that, we should also factor in the proposed amendments that came from members of the public. And maybe just to also indicate that in terms of, I think it's Rule 274-2, we were not required to publish a bill in its final form, and therefore members are free to still propose amendments that were not in the bill as advertised. So I suggest that we deal with the text that we published, and then if members of the committee feel that they also want to amend other sections that were not advertised, we can also do that. But I don't think that we should be going through the section because that is not what we have before us. But obviously, if there is a need to amend other clauses or subsections of the section, then those will be raised. But we should be guided by what we have published in the newspapers.
Honorable members, what Advocate Ramano is saying is not in conflict with what we are doing. He is saying that we are not confined to the bill as advertised. We can add other things if we think it's necessary. But if we do that under general, it is going to confuse the process. Now, I have ruled that we go section by section, but departing from the bill as advertised, but without compartmentalizing the speakers. So let's proceed clause by clause, and bearing in mind that the point of departure is the bill as advertised, but that does not preclude us from raising other issues that came out of public participation. Let's proceed. Who is next? Honorable Mahlatsi? Honorable Mahlatsi? Honorable Mahlatsi? Honorable Masipa and Honorable Melda.
Chair, thank you very much. I just want to really echo what Dr. Lotford said. If the committee wants to add additional amendments, it has to definitely go back to the National Assembly. And in fact, we will have to also go back to the public. That's just what it is. Our mandate, Chair, is very clear that we have got a bill that is published that is before us. And I think the important thing, Chair, is that you'll have to guide us to work on the bill as it was advertised, rather than going all over. We are not here to talk about nationalizing the country, nationalizing the land, and so forth. We are here as sent by Parliament to make explicit what is implicit in the Constitution. Thank you, Chair. I just wanted to emphasize that.
Honorable Masipa. Honorable Masipa, with due respect, yourself and Honorable Dr. Lotford don't have veto powers. This committee is not going to proceed on the basis of the opinion of only two of its members. You have made your point, but not everybody agrees with you. So your points cannot be the decision of this committee. And Advocate Bonani has also guided us, quoting Rule 274, subsection 2. And on the basis of that, I proceed on the basis that we look clause by clause. If you don't want to express yourself on a certain clause, just abstain. Let those who want to express themselves do so. Honorable Mahlatsi, proceed. Honorable Mahlatsi? Honorable Mahlatsi? Oh, she's not there. Honorable Shibambo?
No, I just wanted to emphasize that point, Chair, that I think the issue of mandate we have dealt with that. You have resolved on it. We are now discussing the text of the Constitution. And if these other political parties think that this process is not what they think it is, they've got a right to withdraw, because it's actually withdrawal in Parliament. It's a form of participation. It's a form of saying that I don't agree with this process and everything else. There's no one who's forcing them to be part of this process. We're not chasing them, but if they want to go, they can let them go. And then we'll discuss, and then we'll propose to Parliament, and then they'll object it, and then we'll take it from there. We have ruled on this, Chair. We must not allow all these people to repeat the same thing, because it's now amounting to filibustering, and we can't be held at ransom like that.
Honorable members, we cannot be judges in our own cause. The final arbiter in these matters will be the National Assembly itself. Let's deal with the text, and then if there are other matters that need the intervention of the National Assembly, it is able and always willing to do so. Let's proceed. Honorable Matlatsi.
Chairperson. Yes, Chair. Thank you very much, Chair. I think it is important that we voice our views as members of the committee on the process, just to make sure that it does not resonate as if there are very few people who are supporting the approach that we are taking now. I want to also emphasize the fact that if Honorable Masipa and Dr. Lodred feels otherwise, they are within the confines of the law to feel so. But we are saying as a committee, we are following this particular process that you have proposed. You are providing leadership in this meeting. And we must remind Honorable Masipa that in the Ultra Bill, in the agriculture, they were of a view that the holistic approach must be taken on the Ultra Bill. But it's unfortunate that when we come to Section 25, they've got a different perspective on the issue. Now, based on the rules that have been read to us by yourself and the committee secretary, which allows us constitutionally so, given the mandate of the committee, to continue in this fashion. We should continue in this fashion. If they feel otherwise, they're more than welcome to watch us proceed with what we are intended to do. Thank you very much, Chair.
Thank you, Honorable Matlazi. I'm happy that you also quote an example where the approach that we are taking has been used, which means there is a precedent for this approach in this parliament, and we have to be consistent as parliament and learn from the practices in other committees. Thank you for that guidance. Honorable Dr. Mulder.
I think I propose that
Chairperson, I would agree with Honorable Vanani in terms of Advocate Vanani, in terms of the fact that what is on the table.
Then after we can ask, then we can make further proposals. Let me speak to the chair. Okay.
Yes, I recognize Advocate Ramano. Advocate, proceed.
Yes, no, I was going to suggest that, Chair, we deal with this thing in two stages. First of all,
on a point of order.
Honorable Bambo, you can't have a point of order on a half sentence. Let the speaker finish and then.
It's not Shivambu. It's not Shivambu. It's Honorable Kaba.
Honorable Kaba, Advocate Ramano has not even finished the sentence, so we can call a point of order. Let him finish. Honorable Advocate.
No, I was going to propose that we deal with this thing in two stages.
Mm-hmm.
First of all, let's look at the bill that we advertised and take into account the amendments that we proposed during the public participation process. Once we have done that, then members will then express themselves as to whether they are happy with the bill as it is, or they want to propose further amendments. That is where maybe members can start highlighting that, for instance, maybe subsection 1 also feel that we need to amend this. If the committee agrees, then it will be included in the final product.
Honorable Kaba, you had a point of order.
Since you have ruled on the matter, and you have ruled on the matter, and we were all now starting from subsection 1, and there's no harm in doing that. And I don't understand why Bonani would want to insist that we start with the bill and then deal with other clauses later. What's the problem if we start with, we combine the two processes? You know, it's not an either or kind of situation. We start with one. What are the public, what is the public saying on 1? All right. And then we go to 2. 1 is not in the bill. We all know that 1 is not in the bill. It's outside the bill. We finish the discussion on 1 and then go to 2. What is the bill saying on 2? What is the public saying on 2? What are we saying on 2? And then we go to 3. 3 is in the bill. What is the bill saying on 3? What is the public saying on 3? What are we saying on 3? And when we go to 4, 4 is not in the bill, right? What is the public saying on 4? And what are we saying on 4? And when we move right till we get to item number 9, I thought that was the approach. In other words, it's an integrated approach as opposed to either or. We're integrating the 2 approaches. There's no harm in that.
Honorable members. Honorable members. I think
Chair.
that yes.
No. I before you react, I wanted to say I fully I wanted to say I fully agree with Honorable Gaba that we're dealing with this process concurrently. We're taking into consideration the draft bill, because the draft bill speaks to some of the sections that we're dealing with now. It's not an either-or process. We're dealing with it. So the one-annual approach is mechanical and it doesn't help anything. So let's proceed in the manner that we're proceeding. We're dealing with it in a
honorable members.
Concurrent. So let us proceed in that way. So I fully agree with Honorable Gaba.
Who is this self-appointed speaker? Honorable members, let me say something. I believe that in this process, we must accommodate everybody, make sure that we move together, and let's not have deadlocks on the basis of non-substantial issues or approaches, because what Honorable Advocate Bonani is saying, he's not saying we should not deal with these matters clause by clause. He's just saying, because we still have disagreements on whether or not we are within our mandate, and some people take that view, let's give them the benefit of the doubt. And for today, deal with the bill as advertised. And meanwhile, we will seek a legal opinion on the validity or otherwise of this Rule 24.7.2. And when we come back, we will having a legal basis to say the argument that we are outside of, we can't deal with anything other than the bill as advertised is wrong. And I think in that way, we will be able to move together as a committee. So I want to, with respect, persuade all of you to say for today, let's deal with the bill as advertised. When we come back, we'll deal with the section clause by clause, and no harm should be done to anybody. But we need to move with everybody. We don't want this process to fail simply because of approaches. Honorable Kawa. Honorable Kawa.
Chair is an old hand. My apologies.
It's an old hand. No, but I want you to express yourself on this question, because you first raised the point of order. I am saying for today, let's deal with the bill as is. And then next time when we come, let's deal with these matters clause by clause, so that we don't build unnecessary tensions in the committee. You want to express yourself on that?
No, Chair, no. I said, Chair, earlier on. My apologies. What I said is that let's not approach this thing in a piecemeal fashion. You are not dealing with any other section. We are actually we are dealing with one section, not sections. We are dealing with one sections that have provisions that are mutually reinforcing. My problem is that if you don't start from the top right down, you may actually make a mistake. You know, if we were dealing with a bill that has different sections, Chair, I would understand what you're saying. But in this case, it's one section that has about 9 subsections within it. And those 9 subsections within it, they talk to each other, you know, and you can't isolate any one of them without actually taking it out of context. That's a reason why I said probably it will not make it will not be a problem. You start from the beginning right down to the last section. But if you are proposing that approach, Chair, and I'm sorry, it will have some pitfalls. And well, let me leave it at that for now. Thank you so much.
No, thank you very much. I just thought that we should not dismiss any proposal. I think Advocate Ramono was trying to get a way out of this, but I'm happy that you have restated your position quite clearly. And then Honorable Njozi.
Chairperson, Honorable Klaba is correct, man. Like, this is not hard to appreciate the logic of the efficiency of his proposal. And you are zigzagging now, Chairperson. You had already ruled on this matter, and we were on subsection 1. Now you are allowing yourself to be taken by the storm. On Mr. Bonani's proposal is not contradictory to what we are doing. We start with the bill and then we go to the sections that are not in the bill, or we go section by section, including what is in the draft bill. Is the same thing. We're not. Let's not be confused, Chair. You had ruled. You were hard on me. You see, you are inconsistent, and I think it's your ageism kicking in. Me, you were very harsh on me. Hey, Honorable Ndozi, we're on subsection 1. Now people are coming in that really knew you are falling into the trap. Now, as disciplined, I agreed to be ruled. So now you are zigzagging. I think you are derailing this meeting. I don't know. Maybe you are part of the sabotage that is being planned here. Let's go section by section. Honorable Kaba is most correct. People must express themselves. If they don't have a view, we move. You know, but in an hour, you'll realize we'll be done with the whole section and we'll have an agreement on what must go on. Or we will come back, do the other rest of the sections. 2 meetings later, we'll be finished. But now you are having a problem now, Chairperson.
Honorable Njozi. Honorable Njozi.
I blame Harvard. I think if you had gone to a university in South Africa, you'd be a better Chairperson.
I conveniently fell into the trap because I rely on you as my saviors. But the reason I allowed myself to fall into the trap is because I have a duty to listen to advice and not to reject advice before I consider it. So I did this because I attach great weight to what Honorable Ramano proposed, but Honorable Ramano is not a member of the committee. I will be guided by the member of the committee. You support Honorable Kaba. Let's hear others. Otherwise, we proceed clause by clause as Honorable Kaba and yourself are proposing. Any other view? So there's no other view.
Yes, hand is up.
Who are you? Who
Check
are
on
you?
Check on your screen, Chair.
No, you know, some of these things sometimes don't work. Why don't you just tell me who are you?
Honorable Masipa.
Who?
Honorable Masipa.
Honorable Masipa, thank you that you can still speak, mention your name. Proceed.
Thank you, Chair. Chair, I'm just worried about Honorable Klaba. You know, Honorable Klaba was agreeing with us in the beginning, you know, as to how we should go with this process. But I'm just expressing my disappointment that he has dropped us, you know, completely now. He's not going according to what he initially said. He supported me and Honorable Dr. Mulder and Dr. Lotrit. Yeah, but I think let's really listen carefully of what Advocate Bonani is saying. I think he's making a very, very valid point. He's here to advise us, and let's take his point.
Honorable Masipa. Honorable Masipa. Honorable Masipa. Honorable Masipa.
I'm listening, Chair.
wise men and women change their minds. So what Honorable Kaba did is in keeping with how things happen in life. So we cannot be going back to this change of mind. Honorable Russell.
Yeah, Chairperson, thank you very much. Correctly put, a wise man often changes his mind. That's very correct. That's English in the classroom.
Not only men, also women.
Yeah, no, also. Okay, Prof. Look, Jefferson.
Yes.
What will hurt the fly? You see, I want to allay the fears from Honorable Masiba Hele. What will hurt the fly? Because you see, when we say we go clause by clause or subsection by subsection. We have not said those who want to make reference to the bill should not say or do so. So I'm saying let us address this matter holistically, of course, as proposed by Honorable Kaba, so that we do not have another time to say now today is the day of discussing the bill or trying to interpret the bill. You see, the bill and all the subsections of Section 25 are one and the same thing, and all of them seek to address one and the same thing, which is amendment of Section 25. So I support Honorable Kaba, I support Honorable Ndozi, I support Honorable Shibambu, that we address this matter holistically, and it will definitely assist us in making progress. Thank you.
Honorable members, it was my view that the matter must be addressed holistically. I even said that the rule of interpretation say you must read a document in its entirety. So I want to agree with Honorable Ngozi that I allowed myself to be dragged into the pit or trap, and I thank you, Honorable Murasa, Honorable Kaba, and all other members for taking me out of the pit. Now we are moving forward in an integrated fashion, and anyone who wants to address themselves on Section 25(1).
I still have my hand up on.
Yes, Honorable Melder.
No, Chairperson, I'm not sure that you're out of the trap. I think you fell into another trap. If I'm not mistaken, the discussion for today was on the bill. We were supposed to discuss the bill. A wise person can change his or her mind. I've changed mine, and I'm convinced by Advocate Romano that that should be the correct process and that we should discuss the bill. And if members want to refer to the other sections of Section 25, that's something else. But if you look at holistically at the bill, that is fine. You must make a ruling and then we can see where we go. I agree with Dr. Lotrid. I think the process would be wrong if we do it the other way. Thank you.
With respect, Honorable Dr. Melder, Honorable Romano says you can deal with the advertised text first and with other further amendments later. But other honorable members are forcefully saying, let's adopt an integrated approach a holistic approach and not two stages, because these things are not mutually exclusive. So I want to stand by my ruling that we are going clause by clause. So anyone who wants to comment on the clause 25.1?
Yes, Chair. May I try to persuade the colleagues in the EFF, Dr. Ndlozi and Honorable Shivambu. Colleagues, Section 25, let's look at the structure of Section 25. And because it will help guide the approach we are taking in relation to each of the subsections. Chair, I maintain that we are dealing with only one section. It's not that we are dealing with too many sections. It's just that this section has has about 9 subsections within it. It is in that context that an integrated or holistic approach will help in tackling this matter. The point I'm raising, if we look at the structure of subsection of Section 25, Chair, it has 4 components in it. The first component is a Section 25 component. Section 25 component deals with a deprivation. And I will explain deprivation and how is deprivation different from expropriation, and why we need both deprivation and expropriation in Section 25. The first category I said is deprivation, as provided for in Section 25.1. And the second category is expropriation. Expropriation is provided for in Section 25.2 and Section 25.3. And the third category is Section 24. Section 24 deals with the interpretation of the provisions of the property clause. That's Section 24. It deals with the interpretation of the provisions that relate to the property clause. And then the last category, Chair, from 25.5 to 25.9, it deals with the promotion of land reform. It is between these sections 25.5 and 25.9 that we see the land reform process prominently, stated. I mean, the issue of land redistribution, which is Section 25.5, land tenure, which is 25.6, upgrade of land tenure, which is 25.6, and restitution, which is 25.7. Where Ndlozi, spoke about Section 25.8 and Section 25.9. But the land reform project that is envisaged by Section 25 is anchored largely on 3 sections: land redistribution, land upgrade of land tenure, and thirdly, what you call restitution. Now, I just want to go back to Section 25, deprivation and expropriation. I say that's the position we're putting forward, colleagues, that Section 25, if you look at it holistically, it provides 2 ways in which the state may interfere with property rights. The property rights that we're talking about here are not absolute property rights, because here the colleagues want us to believe that the property rights are absolute, forgetting that within Section 25 itself, there is a transformative character that has got to be taken into account. So in other words, Section 25 does not make it as its primary function to protect the existing property rights. If anything, it is aimed at achieving a social transformation in accordance with the constitutional values such as human dignity, equality, and other things. So it is in those bases that it's critical that when we look at it informed by the aim or the objective or the object of Section 25. When I say it provides for two ways in which the land, these rights may be interfered, I just want to talk about Section 25(1) deprivation and why I argue that it must be retained as is. Deprivation, and I say it's different from expropriation in that it authorizes a limitation in the use, enjoyment, or disposal of property for the sake of promoting a public good without compensation. In other words, and the right in land may be terminated and with no requirement for the state to pay any compensation, as it were. As opposed to what you call expropriation. Expropriation, the people out there will tell you that jurisprudence around the world, attracts some compensation. That's jurisprudence that has been developed around issue of compensation. As soon as you say, expropriation, then legally it's expected that there's got to be some compensation that must be paid. It is in that context, colleagues, that when we deal with expropriation, we have to look at how we approach the issue of expropriation in such a way that we may achieve the objective of having land without paying a cent. So, but the point I'm raising, Chair, that in deprivation, the state may not be required, may deprive a person of his use or enjoyment of the property, and without being required as a state to pay compensation. And that deprivation may happen if it is for public purpose or in public interest. So it is therefore our proposition that let's not get rid of this other instrument that is provided for in the Constitution that the state may actually invoke when we have to deal with issues of deprivation. So it's separate from expropriation. Let's deal with expropriation when as it's provided for in 25(2) and 25(3), independent of Section 25(1) that deals with deprivation. In other words, I'm proposing that we retain deprivation because it has a purpose. We may not have seen it because the state has not passed a law of general application, but it does provide that the land that you may be deprived of your own property if it is in public interest or it is for public purpose without the state being required to pay money for such exercise. Chair, I just leave it that and check if the colleagues are not persuaded.
No, Honorable Kaba, the approach that we have taken now vindicates our position that we must go clause by clause and also helps us not to conflate deprivation and expropriation. And I think we have done very well. I don't see any other hand. We then move to subsection 25(2). Any hand on subsection 2? Honorable Kaba, your hand, is it new or old? Honorable Kaba, do you have a fresh hand or an old hand?
I was muted, Chair. It's
Honorable
my old hand. But
Yeah.
I would love to hear whether colleagues agree with this approach, so that we at least we narrow our arguments before we move forward. Thank you so much, Chair.
Okay. Dr. Ndlozi?
Thanks,
Dr.
Chairperson. Should I proceed, sir?
Proceed before I fall into the trap.
No, subsection 2. Well, I'm in keeping with the ruling, and I really think that it's going to save all of us to just proceed in that way. So our proposal is that subsection 2 must say property may be expropriated without compensation. A, only in terms of law of general application. B, for a public purpose or in public interest. That is how it must read. Property may be expropriated without compensation. A, only in terms of law of general application. B, for a public purpose or in public interest. Now, in the public submissions, there was a very powerful submission to use the word property may be repossessed without compensation, taking into consideration the actual conceptual weight of the word repossession. And we agree with that we can use repossession without compensation to specifically speak to the fact that where this is going to be happening, it will be in the interest of this historic injustice. But we can apply it more directly to those sections that speak specifically to land reform, or persuaded to even use it later. Just to read it for the last time, we propose property may be expropriated without compensation only in terms of law of general application as A, B, for a public purpose or in public interest. Thank you.
Honorable Kaba, you wanted to hear what other members are saying. And all members were silent. Silence means consent. And I want to repeat that your approach has actually helped us to move forward. And Honorable Ndlozi, therefore, has correctly moved to deal with subsection 2. And now I want comments on 25.2. We have dealt with 25.1. Anyone on subsection 25.2?
Chair.
Honorable Masipa, you sometimes forget your name. Proceed.
No, I see you say silence means we are consenting, so we said we don't agree with a flawed process.
Thank you for your general statement, which does not help us because it doesn't say what you agree with. Honorable Kaba, no, sorry, Honorable Shibambo.
No, Chair, I don't hear what Honorable Kaba is saying as justification of retaining subsection 1 as is. Like, there are lots of objectionable things that he says about the international jurisprudence, that when you speak about expropriation, you automatically are compelled to compensate. I don't know where that comes from. Because if we were to rely on our jurisprudence, for instance, we passed laws here in South Africa to take mineral rights that were worth trillions of rands and were owned by private companies, and we didn't pay anything for that. And there was an attempt by Agri SA, by so many other role players in that space, to challenge that. at all levels of our court system, and they all fail dismally. Like, if you go and check our own jurisprudence when we say that the state is going to be the custodian of all minerals, there were so many legal challenges that we entertained at high court level, the Supreme Court, even constitutional court, and that legality was ultimately reaffirmed and enshrined and properly instituted in our constitution. So to then want to suggest that expropriation automatically will come with a compensation, it's a problematic jurisprudence that is referring to. So I honestly don't hear what he's saying. He just wants to retain the section, but the arguments that he puts behind that is wobbly. There is no need for that section because there are many other legislations that protect. It was going to make sense, like if that section was applicable historically. But how do you take people's land and then later on, then when people want to repossess the land, you then say in the constitution nobody can be deprived of? It doesn't make sense. Like, and that is what is going to be a stumbling block, by the way. So the piece by piece method of land redistribution, which you want to take, will be frustrated by that component, because people, every time you say we want to use this land for public purposes or in the public interest, or even for redistributional purposes or land reform purposes, they're going to say, no, we think this amounts to deprivation. And I think you must pay attention to what the Minister of Public Works spoke to when she said that now when there was an attempt to take land for public purposes, for actually ESCOM power line, there was a process that lasted more than 7 years before that land could be utilized for electricity, which is supposed to benefit a lot of people. And then a farm owner says that I don't want any power line passing through my farm. Like, and it just became like that. Well, there's a different option that we can take of opening the constitutional amendment with an affirmative commitment to redistribution of land equitably. So that section in its current form is going to become part of the problem. It's going to become part of a litigious process, which is going to take us differently. That is my submission, Chair. And so I don't agree with Honorable Kaba's retention of that section.
Honorable members, today we are not required to take final positions on any subsection, but we want to hear what different members are saying on this subsection. I think Honorable Kaba has helped us to distinguish between deprivation and expropriation. It may be that some of us have not engaged with that issue. So let's park this issue, reserve it, and say members should go and inform themselves on deprivation versus expropriation. We'll come back to the matter next time. We don't have to finalize it today. Let's proceed as Honorable Ndlozi had started to deal with the subsection 25.2. Any hand on subsection 2? Honorable Kaba, is that an old hand or new hand?
New hand, Chair.
New hand.
Yeah.
Oh, proceed.
Yeah, no, you
go back to subsection 25.1.
I'm not going to go back to deprivation. I was not on expropriation, I was on deprivation.
Okay.
And yes, I think you correctly summed it up. And then let me deal with the expropriation as it is advanced by the EFF, Chair. And the EFF, I'm reading their submission, it says a property may be expropriated without compensation. Is it their position that all property, by all property, I mean all property, may be expropriated without compensation? I don't want to read too much into it if that is not what they mean. But what is stated in black and white, it refers to property, and property may mean everything and anything that is property. Is that their position, that they want that property must be expropriated without compensation? I just want to get that clarity. Thanks.
Honorable Ndlozi, Dr. Ndlozi, Honorable Shibambo, I think is a request for clarity so that we move together with the same understanding. Could you assist us?
Yes, Chair. You will see that, Honorable Klaba, in terms of the current formulation, let us read it together. It says property may be expropriated only in terms of law of general application. A, for a public purpose or in public interest. And B, subject to compensation, the amount of which and time and manner of payment of which have either been agreed to by those affected or decided or approved by a court. So you are amending a formulation that already its central tenant is a property that may be expropriated. This, therefore, should not be difficult when we amend it in the following way. Property may be expropriated without compensation. A, only in terms of general law, law of general application. B, for a public purpose or in the public interest. And then in that regard, the question of which property and so on and so forth is irrelevant if you are going to read it as completely qualifying or qualified by subsection A and B. Then you know which property may be expropriated without compensation and under what grounds. Only in terms of general law of application for a public purpose or in public interest. That is our answer. So it's not a departure from the spirit of the current reference to property. The only introduction is two things: expropriation without compensation, and then the and by following that, or because of this, you then have no need for subsection D at the moment, which is trying to say there must be compensation, the amount of which blah, 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 blah. So in essence, those are the two introductions, the changes that we are introducing into subsection 2, A and B. I don't know if Honorable Klaba would still want any other more clarity, but I think it is sufficiently self-explanatory.
Honorable Klaba.
Yes. Chair, no, I hear what Honorable Josie has to say, and that when a property was inserted, property in general, in subsection 2, as it is stated in the current wording of the Constitution, it was possible because you would not take it without compensating the dispossessed. So in other words, it was possible in that sense. But now, if you talk without compensation or nil compensation, you must then be specific. What exactly are you talking about? Let me just check if the colleagues will not be really vehemently opposed to a new formulation that addresses the without compensation without actually mentioning the words without compensation. And let me just read the formulation. It's there in the clause, but I will explain why I think I would go along with this formulation. It says, property may be expropriated only in terms of law of general application for a public purpose or in the public interest, and subject to compensation, the amount of which and time and manner of payment of which may either be agreed to by those affected or decided or approved by a court, provided we're now adding a proviso. What is new there, Chair, is a proviso, is there in the bill, and provided that in accordance with subsection 3, subsection 3, it's a proviso will go to it. It empowers government to expropriate land. It enables government to determine circumstances under which nil compensation may be paid. That's subsection 3A. That proviso, it reads, let me read the whole proviso, provided in accordance with subsection 3A, the one that I've just spoken about, 3 capital A, where land and any improvement thereon are expropriated for purposes of land reform, as contemplated in subsection 8, the amount of compensation may be needed. In other words, you are essentially separating the expropriation of land from property in general, and then you provide for circumstances under which such expropriation may be, may attract a nil compensation. Nil compensation, in my view, colleagues, it's really equivalent to not paying a cent. In other words, it's equivalent to without compensation. But in this case, you look at the property, you apply the evaluation process, which process may actually take you to a nil compensation. You have read it correctly, what factors must be taken into account in the evaluation process. Why is there any difficulty in accepting that, taking into account the circumstances that will be in legislation and the factors that are in the Constitution may actually deliver a nil compensation? That is my argument. I'm trying to check if the colleagues in this meeting would really not agree that in actual fact we can still achieve without compensation through what you call this formulation. And whichever way you look at it, even if you were going to do it any other way, you still have to start from what is this property, what is the market value of the property, and then you look at the evaluation process that will actually bring it right down to zero, in which case you achieve the objective of a without compensation. Would you not be, colleagues, be persuaded to agree that even if you don't mention the words without compensation, but nil compensation still brings you to the same outcome? Thank you so much.
Honorable members, allow me to say that the key element in the rule of law is that no action must be arbitrary. Now, what Honorable Kaba is talking about, this evolutionary process, guarantees that we follow the due process of law to avoid arbitrariness. So when we comment on his proposal, let's bear in mind that the rule of law prohibits arbitrary actions on the part of the state. But I leave that in your hands. I think he has made his point. Let's engage him. I don't see any hand. I don't see any hand. But see, comrades, the other thing is we don't want to rush anybody. Honorable Dr. Ngozi has made a proposal, and Honorable Kaba has amplified his proposal. So it may be that other members still want to go back and think about this. and that space will be allowed. I see Honorable Ndozi's hand is up.
Thanks, Chair. I don't have the full appreciation of Honorable Klaba's logic. Maybe if we had seen what he said, I couldn't quite. It wasn't sufficiently clear whether he was reading the current bill or he wasn't. I don't know, but I want to address this question of Neil. That no, we would not agree that with the usage of a Neil. We have to be very clear, without compensation. That's number one. And in terms of the current formulation, in the current draft bill, there are problematic aspects which, for instance, speak to the inclusion of a court. I think public engagements on this were sufficiently clear. I don't want to canvass those grounds again. We would be completely opposed to this, but I may be misinterpreting Honorable Klaba's submission if it is different to the draft bill's formulation. So maybe if we saw it, because I don't know it. He's working on a submission. Our submission, at least he has it, he has read it. If we could see what he was reading, provided it's different to the draft, the formulation in the draft bill. If it's about the formulation in the draft bill, we completely don't agree. This is a compromise position that will put you back in the same position where you will not be able to redistribute land. You will come across long-winded, litigious processes of valuation, of back and forth in a court, because if you get that valuation wrong, that will lead you to nil compensate. It's a reactionary position that does not help. Either we want to get the land reform process right, or we don't. So, and the last point I want to make is, remember, there's still going to be legislation. So don't write the legislation at this level. So the other question relates to the arbitrariness that the chairperson is speaking about. Law of general application is the guarantor of non-arbitrariness. And I think Harvard would have sufficiently canvassed the honorable chairperson pedagogically on this. So when we say expropriation of land without compensation, when we say only in terms of general law of general application and be for a public purpose or in public interest, we have in mind that there's going to be an act which speaks to the detail of those things. Like at this level, we don't have to. We must establish that a property may be expropriated without compensation, and we qualify only in terms of law of general application for a public purpose or in public interest. At this level, we must be completely unequivocal. Completely unequivocal. Otherwise, you will be caught, as the Honorable Shivambu indicated, in long processes of litigation where you want to put power lines and you take 7 years because some farmer is going to tell you, this is my land, you can't do anything. Yet you have proven that what we want to do here is not about us. It's about either a historic injustice, number one, or number two, it's about electricity which is going to people. It's about people getting access to power, to the dignity of having electricity. If you are unequivocal, you will fall into the traps of the last 27 years.
Thank you,
I don't know if Honorable Klaba wants to come back if I've misread him. Thanks.
Honorable Dr. Ndlozi, thank you for bringing some humor so that we don't become tense and explode. Thank you very much. And I recognize Honorable Shivambu and Honorable Mwashat.
No, Chair, the other thing maybe that could be helpful, which we have done ourselves long time ago, is that we have written down our proposed phrasing of the entire Section 25 and all subsections, and proposed much more concretely on which sections must be deleted and which ones must be rephrased differently. And I don't think there's anything wrong with the ANC caucus or the ANC as a whole doing so. Like, actually, not doing so. It's it borders on cowardice. Like, why don't you just say what you want, and then we then deliberate on that basis? You went into elections, in your manifesto, you said you're going to expropriate land without compensation. 57% of the electorate in South Africa gave you the mandate to do so. So why are you not clear of what you want? Because majority of your submissions in terms of the phrasing of each subsection is wobbly. It's all over. There's no clarity of what you stand for. Maybe we must give each other an opportunity to check, because you said that today we're not finalizing. Perhaps the ANC must go and write what you think should be the amendment of the Constitution, and then we then look into that from that point of view. There's nothing wrong with you taking the caucus position on how the Constitution must be amended, because now we don't hear you. We are speaking, but there's no clarity of what exactly are you saying. Please help us, Chair, so that we conclude on these things. We've got political power, we've got a mandate from our people. Let us take decisions. If you don't take decisions, it's okay. We'll accept that. We'll understand that the ANC doesn't have a position. But at least write down, it's only 9 subsections, and say this is how we think the phrasing should be like, and then we'll take it from there. I don't think that there can be a problem in that, because majority of the submissions we're giving here are not very clear.
Honorable members, I'm happy, as Honorable Chibambo is saying, that today we are not obliged to take final positions on anything, but we need to hear one another so that we can then determine how do we start a movement towards finding each other. Having said that, I've recognized Honorable Murasetla, Honorable Matlatsi, Honorable Kaba. Honorable Murasetla. Matlatsi. Kaba.
Thank you, Chair. Chair.
Okay, proceed.
Thank you very much, Chair. Should I proceed? Because I see Honorable Mzagara wants to come through.
No, you are already on the stage. Proceed. It doesn't. The order doesn't make sense.
All right. Thank you very much, Chair. I think it is important that Honorable Shivambu must not preempt what the ANC ought to do. Of course, we've got our own mandate, and we are quite clear in terms of what we need to do. In fact, what Honorable Kaba was indicating was just to give a framework in terms of how we want to phrase the actual content of the bill. Now, if he wanted us, we are not going to also be dictated by Honorable Shivambu on how to manage our issues in this particular meeting, Chair. We might share almost same sentiments in terms of the expropriation of the land, but if he wants to raise his views of the EFF, he must do so without necessarily preempting on what we want to do. We will not be dictated to. However, Chair, I'm of a view that if we are to take that route of making submissions per clauses, as we have done before, we should be given an opportunity to do so. And if we, because I think the meeting has now taken 3 hours, if we were to give a framework on each and every clause, because here we are not alone, there's public that is listening, they ought to understand why are we coming with a particular context in terms of, the particular content, that we need to give context to it, so that we must not look as if we just came up with words in J they are informed by a particular perspective and policy imperatives. So if we're given an opportunity to submit to the committee per clause, let it be, so that as we debate and discuss, we discuss holistically. And they themselves, honorable members of the EFF, they should do the same and submit their own perspective so that we are able to see whether we are able to fund one another or not. Thanks, Chair.
Honorable Mahlatse, thank you very much. Honorable Murasetla.
Yes, Chairperson.
Honorable Murasetla. You have a problem with your gadget. Honorable Murasetla. I will come back to you, sort out your gadget, and now I will go to Honorable Kawa.
No, I think Mahlatse has covered the point, and you also have covered it as well, Chair, that in this meeting, we are just presenting our opening bids. We will then, at the next meeting, then reconcile the position with a view of coming up with a text. Maybe in between now and the time when we meet again, the different parties would, meet. There would be bilateral and multilaterals with a view of trying to, narrow a disagreement, so that when we come back, at least we know where each one stands on a particular issue, and we have isolated issues of agreement and issues of disagreement. And in that way, it would make your job much easier, Chair. So it's good that today we are stating our positions, to allow the process, not to finalize the text now, but to allow the process of bilaterals, so that when we meet next, it would be easier, very easy to find each other and then produce the bill, as it were. Thank you so much.
Honorable members, the process determines the quality. The process determines the quality of what you are doing. I can see that you are at one on the process, but Honorable Murasika is still.
And myself, Chair. Yeah.
Who is myself? Honorable Shibambo. Okay.
Yes. Yeah. No. Look. Yeah. I look. Our phrasing, we have done that several times before, officially in the committee. I think both the constitutional review report and the report which we're supposed to be deliberating from has got the phrasing which we had proposed, and it even says that this is a phrasing which was proposed by the EFF. By no means we're not averse to the bilateral engagement. So if it requires that to reach consensus, let's agree on bilateral. We can actually even try to set a physical where we then deliberate on all of these issues. And if we don't find each other, we don't. If we find each other, we do. And then.
Okay. Thanks. Honorable Mrosata.
Chairperson, and bilateral does not just limit it to everyone else.
No, wait. Let me say on bilateral, I think it's very important so that some of these things can be dealt in the bilateral. So when we come to the committee, we deal with the most essential things. So let's agree on bilaterals. They will take place before the next meeting. Okay, for instance, on the question reserved on deprivation and expropriation, there must be engagement on that. On the formulation of the EFF and the ANC regarding the evolutionary process and the nil compensation, those are the issues that can go to bilaterals, and the circumstances which must be dealt with by the law of general application that can also be taken there. So we agree. Honorable Mrasata. Honorable Principal today is born before technology. He used to accuse me of being born before technology, but today that's his turn. Principal, we will send you back to the classroom now. Honorable Mahlatsi. Honorable Mahlatsi.
Is an old hand, Chair. Sorry.
Okay, thank you. Honorable Dr. Njosi.
No, thanks, Chairperson. I wanted to guarantee Honorable Mahlatsi that we are not in any position to dictate to anybody how they should make their submissions and all of that. We're merely appealing, we're making an appeal that we want to know what the position of the ANC is, because we don't. And it is only fair to request it in writing, as it has not been given. And I want to extend this to the IFP and the other political parties as well, Al-Jamaa, NFP, ACDP, if they want to do the same thing, because we don't know. And it is only fair because it's going to help us to understand and then move, knowing what the position in clear black and white terms says. Secondly, bilaterals are fine, they are proper, I get that, but we must, Honorable Chairperson, with your guidance, we must not hesitate, comrades. Our people were unequivocal of what must happen. We must execute it with precision and with speed. We must not take too much time. This is a historic moment in the opening words of the Chairperson. Let us plug into this historic moment with the greatest confidence that it will be executed to the best of our ability, and there will be peace in a land where our people now own majority of the land. We must not hesitate. Ningasabi, ningoyiki. Let us expropriate. It is upon us. We are the people who must do it. We are that generation. Let's proceed. Let's not dilly-dally. Either we want it or we don't. Either we do it or we don't. No piecemeals. Let us do it and stand tall. That is my submission. We can proceed from here to wait for the submissions, initiate bilaterals, but hesitation, my poor comrades. Fear not. Thank you.
Honorable members, I think I agree with all of you. And in particular, the request that, the new formulation that Honorable Kawa expounded, comrades from the EF, honorable members from the EF are simply saying, amplify it in simple terms, let's understand it. They are not saying they reject it, they want it to be clarified in writing. So I'll request that Honorable Kawa should do that, and that before the matter even comes back to us, it must go into those bilaterals. And that also goes to the question of deprivation versus expropriation. Those matters must be dealt with there. But I think that we are still continuing to go clause by clause, but for the clauses that we have dealt with, there are issues that need bilaterals and clarifications. We pack them and refer them to that process. And when we come back next time, we will proceed with clause by clause and identify if there are other issues that also needs to go to bilaterals. And when all the issues meant for bilaterals have been dealt with, then we come back then again from clause 1 and see where have we managed to reach one another. And we should conclude this process timeously. And honorable members, I really must thank you for the constructive engagement and the battle of ideas which unfolded peacefully and with due respect to one another. And let that be the approach until we discharge this responsibility. Honorable Dr. Ndlozi, is that an old hand?
Thanks, Chairperson. It is indeed. I have now lowered. It's a digital hand. It's now lowered.
Oh, okay, wonderful. Honorable members, we will meet again on Friday next week. Now, what I want to request is that the bilaterals take place before Friday next week, and actually that we should not confine ourselves to the clauses we already dealt with. We may also venture to exchange ideas on the other clauses so that when we come next week, we are able to make substantive progress. And I want to thank you very much and wish you a very good weekend, and also request that you follow the protocols announced by Dr. Mkiza and the Cabinet and the Command Council, because the COVID-19 situation doesn't seem to be abating. So keep safe and keep healthy, and let your ancestors and the Almighty spare you so that you can proceed this project. Thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair.
Honorable Lesoma. Honorable Lesoma.
She's out of the meeting, Chair.
Hello. Hello. Hello.